So I'm going to be discussing COVID-19 and civil liberties generally, really its intersection with the Canadian Charter of Rights and Freedoms, and in particular, two issues that I'll get to in a moment. I first want to make a comment about the fact that we keep hearing that COVID-19 is unprecedented. I think we've heard that word in the last 6 months almost as much as the word onboarding, which somehow has become the most used word in the English language. And the point I wanted to make here is that while some of the social issues arising from COVID-19 are indeed unprecedented, it's been a very long time, obviously, since the world has confronted a pandemic of this sort. In terms of constitutional law and civil liberties, a number of the issues are actually quite predictable and ones we've faced before in numerous eras of Canadian constitutional law. So there's a familiarity to some of these questions, and there's a perennial aspect to the debate that arises when we face social challenges of this sort and that implicate the relationship between and among individuals, citizens, public officials, and the state. I do think it is fair to note that it is perhaps overlaid by particularly challenging issues that plague our society today, that really go to the nature of our community, the strength of our social bonds, the fact that our society is racked by deep inequality, the presence or lack thereof of cohesion, really among the various constituencies, and the proliferation of misinformation and the ease with which that can be disseminated. So that, I think, does present particular challenges in the current context. So the two issues I want to talk about, obviously very, very briefly, just setting the table, is mobility. So really the right to move around within our broader political community. And then more briefly still, just a couple of thoughts about vaccination, which even in the last few weeks, I feel like the discussion has shifted a bit. So to start with mobility rights, so here I am referring specifically to the Canadian Charter of Rights and Freedoms, which expressly protects mobility rights in Section 6. There are two subcategories of protection. One is a protection solely for citizens, so actual Canadian citizens, which is an unrestricted right of mobility both within and, importantly, beyond Canada's borders. So this unrestricted right, for example, to be able to leave and enter, again, Canada at will. And then there is a second clause in Section 6 that importantly extends beyond citizens to permanent residents and specifically relates to the right to move to provinces for the purpose of setting up one's residence and pursuing an occupation. So there's express protection for mobility under Section 6. I think there is implied protection for mobility under Section 7, which guarantees the right to life, liberty, and security of the person, and the right not to be deprived of those interests except in accordance with principles of fundamental justice. And there, I think mobility can easily be correlated to our liberty interests, but also perhaps to our security of the person interest, depending on the effect of a mobility restriction. A couple of points to make about these two sections and the Charter of Rights. As many of you will know, of course, all of the rights and freedoms in the Charter of Rights are subject to what we call reasonable limits, which are found in Section 1 of the Charter. Section 1 on its face applies to everything, all of the rights and freedoms in the Charter, but students of constitutional law will know that, in fact, violations of Section 7, life, liberty, and security of the person, historically have been very difficult to uphold as reasonable limits under Section 1. There is no such historical reluctance on the part of courts to save, if you will, violations of Section 6. So there's a little bit of a different context under which how we would assess what a reasonable limit on those rights are. But, and contrary, the notwithstanding clause of the Canadian Charter of Rights and Freedoms, which allows for legislatures to uphold laws despite the fact that they may violate certain charter rights, the notwithstanding clause can be used against Section 7, so it can insulate a law against a violation of Section 7. It cannot insulate a law against a violation of Section 6. So Section 6 is outside the scope of that notwithstanding clause found in Section 33. I also just here wanted to point out that outside of the Charter, mobility and the right to, or the incidence of movement within and beyond Canada also raises issues of federal-provincial relations. So there's an important federalism aspect to this, dealing with both the inter-provincial boundaries and works and undertakings and roadways, as well as the policing of our national border. So I just wanted to put on the table a number of principles I think that arise. These aren't all necessarily constitutional principles, but clearly there's a basic expectation of a certain standard of liberty in terms of our political community. And there are certain things that the Charter expressly guarantees as incidents of citizenship. And I think that are also impliedly guaranteed as incidents of citizenship. And we can talk a little bit about what we mean by citizenship, whether we mean the actual legal status or some deeper membership in the community. I think that, and I really come back to this a lot, this issue of social cohesion is also very important. And by that, I also mean just the political reality of the need to have a certain level of buy-in, if you will, to the various restrictions that are put in place. So we do not have the kind of society where you can have a fully top-down approach to how we manage COVID-19. There does need to be a significant amount of public acceptance of the decisions that are made and the authority by which they are made. And then, of course, a very important principle under the Charter is accountability of the state and its officials for the decisions that they make. And in some respects, I think that has been, reasonably adhered to, and in other respects, perhaps some of the processes around that decision, the involvement of the executive branch of the state, perhaps to the detriment of the legislative branch. There has been concern raised about that in the context of what's been happening over the last seven or so months. So I want to discuss a recent decision from the Newfoundland Supreme Court, the Newfoundland Superior Court, called Taylor. And this was really the first decision we have expressly dealing with a challenge to measures taken by a province that restricted mobility for everyone. So this was an order taken under what's called the Special Measures Order that was under the auspices of a public health act that had been amended actually just before COVID. So it was not in response to COVID, but there had been some significant changes to that act. And under that act, there was a special measures order taken that prohibited everyone from entering Newfoundland and Labrador. So the most stark infringement of mobility within the context of the national and interprovincial movement that you could imagine. There were some exceptions for residents. There were also some exemptions for asymptomatic workers and other individuals that were considered essential, subject to having to, of course, quarantine for a period of time. And then there was a discretion to permit some individuals in what were called extenuating circumstances. So Taylor, who hailed from Newfoundland but was living in Nova Scotia, sought entry through the extenuating circumstance provision to attend her mother's funeral. And she was initially refused. The legislation does provide a means for reconsideration. And after a period of about a week, She was ultimately successful in the reconsideration, but she was kept out of Newfoundland for the critical period of time. And that was part of a challenge that was launched against this entire regime, including this very novel, if you will, restriction on mobility rights for Newfoundland, which has been replicated to a great extent in what is commonly called the Atlantic bubble. So some of the characteristics affecting this suite of decisions that the court took advantage of, that the court took notice of and really recognized, was the novel nature of the coronavirus. Its severe clinical effects were things that the court was prepared to accept, and the exponential growth threat presented by simply not having any restrictions at all. And they also relied on modeling to show the effect of having these kinds of mobility restrictions and not having them, as well as the threat posed by non-compliance were you to simply let people into the province and subject them to orders. And I just have a quote here, I'm not going to repeat it, but it was quite a famous quote made by an official of the WHO, Dr. Michael Ryan, which was essentially a plea to public officials to move fast and make decisive decisions, even knowing that they might not be perfectly justified, that is the kind of response that was needed. And the Newfoundland court actually cited this, which gives you a sense of what it was going to then do. So importantly, the Newfoundland court found that Taylor's mobility rights had been infringed, like there was, at least at the first stage of charter analysis, an infringement, and they talked about what they said was a bare mobility right under section 6 sub 1, which I talked about in the earlier slide, and they affirmed, or the judge affirmed, that this was something that was fundamental to nationhood. So it is a bit of an extension of what we normally think of as falling under the mobility rights, which to the extent that it just relates to the bare freedom to move around. They did not find that there was a violation of section 7 of the charter. And they did find that Newfoundland was actually within its jurisdiction to impose these mobility restrictions, because there was no countervailing federal law on the books to try and override the province's decision here. Now, ultimately, the court found that the mobility restriction for Taylor was saved under section 1, and they found that it was a reasonable limit given the overall context, given the information known to the public officials at the time, and given the balancing that you needed to achieve. One thing I will just note is that an implication of the Taylor decision, because they proceeded under section 6 of the charter as opposed to section 7 of the charter, is that the mobility right they are recognizing would appear on its face to apply to citizens only, to people with the status of citizens, as opposed to permanent residents, because the clause they are relying on in the charter is directed at citizens. So that, I think, is perhaps a troubling implication of dealing with a mobility challenge under section 6 of the charter, as opposed to section 7, which applies to everyone. There's one other point I want to make about this case, and this is a more technical point of constitutional law, but it relates to something that we call standing, which is the right to actually present a case in court. So Taylor was joined in this case by the Canadian Civil Liberties Association, which sought the right to appear and both to support her claim. But the Canadian Civil Liberties Association also wanted to challenge other aspects of this regime, in particular in very, very broad enforcement powers given to the public health officials should someone breach an order. Because Taylor was never permitted in the province, she was never subject to those enforcement mechanisms. And the court permitted the CCLA to make arguments about the infringement suffered by Taylor herself, but not this broader suite of concerns that it raised, because it said that there just weren't sufficient facts before them. So this is could be a troubling sign for the litigation of other charter claims if other courts take a similarly narrow view to when third parties can raise issues regarding the legislative validity of provisions where you don't have an actual plaintiff there or you don't have any evidence as to how they've been applied. So I did want to raise that because it is one of the first cases that we've had to deal with this. So finally, I'll just spend a couple of minutes talking about the second issue, which is vaccination. And you know, I've put here, this has been a long time coming. We've been in the grips of a very difficult debate and discussion about this sudden turn, this suspicion in society among a significant proportion of people around vaccination, what's called vaccination hesitancy. I think this is a function of those weakened social bonds that I was talking about. And also, we have an extraordinarily individualized focus that really prioritizes choice and autonomy, which I think is, of course, very positive. But then when you put that in the context of this really almost existential threat that we're facing, it can be very difficult to know what to do. And so just some pending issues, of course, is at such time as a vaccination actually becomes available, there's no guarantee that it will, of course, what will be the regime under which we administer that? Will it be mandatory? Will it be mandatory in effect if we make it a precondition of accessing certain services? The governments don't seem eager to go there. And how will our human rights regime really deal with this in terms of accommodating individual choice? How will we accommodate, for example, claims of freedom of conscience in respect of, again, this very serious challenge that we face? And the final issue I just want to raise with respect to vaccination is there are other charter issues, potential charter issues, in terms of the provision of vaccines and how we prioritize among different groups and which groups receive priority. How we map that onto what I talked about before in terms of the pre-existing social inequality and disadvantage. And that's going to raise some extremely difficult issues for the state. So I'll end there and look forward to your questions.
Thanks very much, Carissima. I'm sure people have questions, but we will save them to the end. If you do have questions, please feel free to put them into the question and answer box. And otherwise, though, we will shift gears and hear from Professor Skolnik speaking about physical distancing and homelessness. Over to you, Terry.
Obviously, I'm talking with the microphone muted. Hello, everyone. Very nice to see you, and thanks for attending today. And I see some of my students are here too, so thanks for being here. Today, briefly, I'm going to speak about the impact of physical distancing laws on homeless people. Part of the point of the presentation today too is to make you think maybe a bit differently about homelessness. It's a tremendous tragedy in society that homelessness is an ongoing problem. We know that it's a condition where individuals have a lower life expectancy, they're more likely to be assaulted and more likely to be victims of violence, to struggle with addiction, mental health problems. And this is kind of all before the law even kicks in. And what we're going to talk about today is kind of how these physical distancing laws make their very difficult lives already worse. But if we're even going to get there, I kind of want to take a bit of time just to explain why homelessness isn't just a factual condition, right? A situation where somebody perhaps lives in the streets or lives in a shelter. I want you also to think about homelessness as a legal condition. And what do I mean by a legal condition? I want to show you that it's a condition where individuals are subject to other people's power, always vulnerable to a certain type of interference by other people because they don't have real private property rights. So we're going to kind of see today a bit of a bridge between property law and between the criminal law, and we're going to see how it plays out in the pandemic. So that's what I'm going to discuss today, and my presentation is going to take place in 3 parts. The first part's going to talk about the particular vulnerability of homeless people. And part of this builds on some work that I wrote in a book chapter in this book called Vulnerable, that was an edited collection produced by several professors at University of Ottawa and abroad as well. And I think the term vulnerability really captures something unique about homelessness in society. And that's what I'm going to show you. I'm going to try to show you that there's something about homelessness as a legal vulnerability as much as a physical vulnerability. I'm next going to speak about the impact of these physical distancing laws on homeless people. What is it about the development of these laws and their implementation that impacts homeless people uniquely? And I'm going to end the presentation by speaking briefly about the civil liberties implications of physical distancing laws. So let me begin first with this first part of this presentation about what makes homelessness a unique legal and physical condition. So this is kind of the starting point for where we'll go. Every single act that a person has to do has to be done somewhere, right? It has to be done in public or in private, on public property or on private property. And this is an argument advanced by Jeremy Waldron and Christopher Essert, and I'm building a bit on their work here. So if everything has to be done in public or in private, well, this creates a unique problem for homeless people who often have no private place where they can alleviate their needs, right? Something as basic as going to the bathroom or sleeping or sheltering themselves must often be done in public. But here, of course, is the problem, is that in many cities in North America, if not most, there are laws that regulate public property, how people can alleviate their needs, what they can do in the public sphere. So if you look at a city like Montreal, for example, there's prohibitions against sleeping in parks after hours and sleeping in a subway, public urination, all behaviors that are banned in the public sphere, yet permissible in the private sphere, right? We can do these acts within the confines of our homes. We can't engage in them in public. And if we do them in public, then we risk a fine. So that's kind of how the law publicly regulates different types of need alleviating behaviors in public. And the instrument that the law uses are called quality of life offenses. There's these offenses that aim to increase the community's quality of life by prohibiting these types of behaviors that are deemed incivilities by public authorities. So that seems to bar homeless people from alleviating their needs in public. Now, what happens if they want to alleviate their needs in private? Here's the other problem. The other problem is that there's something very unique about private property. And is that if we want to use somebody else's private property, well, we require their permission to do so. We have to be granted access to use that space. And access to use that space is a precondition to doing any act in that space, right? If I want to go into a coffee shop and use the bathroom and they don't let me into the coffee shop and use the bathroom, well, I can't do any other act in that space. I can't get a coffee, can't sit down, I can't stand, I can't read, whatever. If I don't have permission to access the space, I can't do any act in that space. And I think this is kind of the other aspect of homeless people, how they navigate through their daily experience, is that often they're not granted that access to use private spaces. You could think of an example as basic as, oh, you know, this space is for customers only, or a bathroom is broken, or what have you. So you can see that the core problem here isn't that just that the law prohibits homeless people from doing a certain act in public, but they're often not allowed to do that same act in private because they require someone's permission to use that space, permission that can be granted or denied at the will of whoever controls the private property. Well, the cumulative effects of these two prohibitions, one in public and one in private, is that homeless people are always vulnerable to some type of interference by other people, right? If they're in public and they try to alleviate their needs, well, there's a risk that they'll be fined by the police. If they say, well, I'd like to obey this law, let me go to a cafe, let me go to a homeless shelter, well, they still need permission to access these shelters. And not all shelters are barrier-free. Many impose different types of conditions to enter, for example, an abstinence requirement that are not consuming alcohol or drugs. So what does this mean? It means that, well, for homeless people, in a sense, if you can't do an act in public and you can't do it in private, well, there's nowhere you can really do it, and the act itself becomes prohibited. So that's kind of, I think, the reality of homelessness that we don't generally think about. It's a type of vulnerability to other people's power anytime that homeless people want to do something as basic as alleviating their needs. Now, this is a huge problem. And if you look at when the reality of police coercion steps in, it becomes even worse. And this is going to be the second part of my presentation, where I kind of give you a sense of, you have an idea now of this vulnerability that exists for homeless people. Well, what happens when the state steps in to coerce and punish homeless people for doing something as basic as trying to shelter themselves or stay in a group so that they can protect their security and dignity. So interestingly, homelessness traditionally was regulated by what are called vagrancy laws. And these vagrancy laws, if you trace their origins, it goes back to a 14th century law called the Statute of Labors that was imposed actually after a pandemic, after the Black Plague had decimated a significant portion of England's population. Well, they created a law that prevented homeless people, people more generally from wandering, and so on and so forth. So the law was generally an economic measure that tried to prevent people from seeking work and employment abroad and trying to leverage better working conditions against employers. But it was eventually used as a term to prevent people from sleeping in public property or not having a stable type of employment. Eventually, these laws were struck down and replaced by what we have today, these quality life offenses that continue to regulate homelessness. So although we have kind of, in a sense, come full circle, and that we see that, once again, homelessness is kind of becoming regulated in the midst of a pandemic, well, now we're kind of forced to confront again these basic questions about what people are allowed to do in public space if they have no private place to do these acts. Much of the problem that we have now is that because homeless people don't have a real private property right, well, they have to stay in public. And where do the police patrol? Well, police don't patrol private property. They're out patrolling in the public sphere, which means that homeless people are generally much more vulnerable to surveillance by the police. It's no surprise that if you look at most municipal bylaw offenses, low-level offenses that are committed in the city of Montreal, especially for acts like sleeping on a subway bench or camping after hours in a park, well, they're mostly committed by homeless people who have nowhere else to go. So that is kind of a bit of the dangers about the regulation of homeless people, is that they don't really have the same type of protection that people with access to housing have against police surveillance and coercion. And it's something as basic as the state's capacity to regulate homeless people to a much broader extent, right? The state can't go and patrol how people alleviate their needs or sleep in their homes, but the state can very easily regulate those same behaviors in public. Why is that? Well, we know that in the common law, we have a huge expectation of privacy that protects our interests within our homes, right? If the police want to go into a home, the problem isn't that just there is a physical barrier that prevents them from entering, but there's a whole bunch of legal protections that the common law affords the home, right? An expectation of privacy, a warrant requirement, all these protections that homeless people do not benefit from. And I think this is kind of really getting to the core of what the problem is. It's not just an issue of vulnerability to police and private power. It's really an issue of being constantly surveilled as well and being constantly vulnerable to being fined for an activity that everyone must do, right? We can't abstain from sleeping or from going to the bathroom. These are things that everyone has to do. And I think it's a tremendous way to demean human dignity to then punish people for doing these acts in public where they have no private place where they can do them. So this brings us to the next point and the final point, which is, well, what are kind of the implications of these physical distancing laws on homeless people's civil liberties, right? Especially if they do not benefit from the same extent of privacy or the same protection from interference because they don't have access to housing. Well, one of the main problems is that with the advent of physical distancing laws, right, which are laws that either require people to stay a certain distance from one another or prevent a certain number of persons from congregating together. Well, one of the problems is that homeless people often have to stay together for safety reasons. Why? Because there's a much larger chance that they're victims of assault in shelters of sexual assault as well compared to the general population. And if they're unable to stay together for safety reasons, well, it puts their security at risk as well. So there's a risk that homeless people who try to protect their own safety by staying together in a group risk being fined a tremendous amount of money for violating these laws. In Quebec, for example, the current fines for violating physical distancing requirements is about $1,000, and with fees and all applicable surcharges and whatnot, I think it's approximately $1,546. Consider the potential for a homeless person to continue to be homeless if they, on top of the challenges that they already face, now have to pay a $1,500 fine and may well have secured their rent for several months. What are some of the other problems with these physical distancing requirements? Well, the other problem is that in many cases, it may be that homeless people have to stay in a shelter to obey some of these laws, right? If they can't sleep in the subway or they can't sleep in a park after hours, well, then the law is forcing them to stay in a shelter in order to obey the law. The problem is that in many homeless shelters, there's problems of violence, there's problems of overcrowding, there's a much higher risk of transmissibility of communicable diseases like tuberculosis. And with the advent of COVID, there's also a risk of that disease becoming propagated as well, placing homeless people in a huge catch-22 situation where they're forced to either perhaps violate these physical distancing laws by trying to maintain their safety on the one hand, or being forced into shelters where they may be exposed to the virus. So I think this is an interesting point about how these physical distancing laws impact homeless people uniquely. What are the civil rights implications for homeless people? What rights might be affected by these types of punishments and these types of laws? Well, I think one of the most important areas that are impacted, or one of the most important rights that are impacted by these laws, is the right to be free from cruel and unusual punishments. And my contention is that the use of very expensive fines against homeless people, rather than adopting some type of more public health-centered approach, should constitute a cruel and unusual punishment. If you think about the impact of these fines, well, not only is it that it deprives homeless people of money to pay their rent, but if their fines go unpaid, it's often disclosed to a consumer reporting agency, it impacts their credit rating adversely, prevents them from being able to secure loans, open bank accounts, access utilities, and so on and so forth. And also these debts are often converted into civil judgments where the state is able to seize property for these unpaid debts. Now, I think if you want maybe an interesting lens through which we can look at this, and I'm going to end on this point, the recent decision in R versus Boudreaux provides an interesting framework for how we can think about these physical distancing laws constituting cruel and unusual punishments, when imposed on homeless people. So in Boudreaux, if you're unfamiliar, I'll give you a quick summary. It was a case where the defendants contested the mandatory victim surcharge that was imposed in Canadian criminal law, which meant that each person who was convicted of a criminal offense had to pay a mandatory amount of $100 or $200. And judges couldn't waive this requirement, it was mandatory. And the court ended up striking down this mandatory victim surcharge as a cruel and unusual punishment on the grounds that it imposed the equivalent of an indeterminate sentence on homeless people. Meaning that for those who were impecunious or who were homeless, unfortunately, they weren't able to pay off the fine for perhaps the rest of their life. The other reasons that the court invoked was a kind of perpetual risk of arrest and imprisonment that hung over the heads of homeless people. So those were kind of the animating concerns at the forefront of striking down this mandatory victim surcharge. I think many of the same concerns are raised in these cases of physical distancing laws that are imposed on homeless people, and for a bunch of reasons. I think first, if you look at the quantity of the fine, say in Quebec for violating a physical distancing requirement, it's $1,500, which is 15 times higher than the amount that was imposed in Boudreaux for summary conviction offenses. Right? Instead of a $100 mandatory surcharge, the fine here is $1,500. I think another reason why it constitutes a cruel and unusual punishment is that in many cases, homeless people won't actually be able to contest the fine for a variety of reasons. it might be personal circumstances related to addiction or mental health issues, and might bar them from factually asserting their rights, such that in many cases, even if the fine is imposed with some level of judicial discretion, they'll never actually benefit from that discretion in practice. And on a final note, I think if we're saying that cruel and unusual punishments can only take place when the fine is mandatory, I think it would lead to an absurd conclusion that the state could impose on $100,000 fine on a homeless person, as long as that fine has some type of discretionary element, even if most homeless people will not benefit from that judicial discretion. So that's kind of, I think, a way that we should look at homelessness, not only as a situation that was catastrophic even before COVID-19 hit, but it's something that is not only endangering homeless people's lives, especially to the extent that they are forced to stay in shelters, but the risks of coercion are unique on homeless people versus other members of society. So on that note, I look forward to the Q&A, and thank you very much.
Thank you, Professor Skolnik. While we're welcoming back Professor Mathen, the first question has come across the Q&A and is for you, Professor Skolnik. Hello, Professor. Further to your point about increased patrolling and regulation of public spaces and its impact on people experiencing homelessness amidst the pandemic, what are your thoughts on the encampments we've seen erected across Canada, particularly in the downtown east side in Vancouver, although I will say we have a number in Toronto as well, and the rights for people experiencing homelessness or lack thereof that come with these quasi-public properties?
Thank you, Madeline. It's a fantastic question, and there's been a bunch of judicial decisions that have looked at this. Two of the most, I don't want to say famous ones, but two of the most cited ones or noted ones are Victoria versus Adams and Abbotsford versus Shantz. And I'll give you a quick breakdown of how courts looked at these questions, then I'll give you my thoughts after. Both cases dealt with a situation where this relevant city prohibited homeless people from erecting temporary shelters in public spaces, especially in parks. And at the time that the cities imposed these laws, there was too few shelter spaces for the number of homeless people in the city, which meant that if all homeless people tried to obey this law at the same time by sleeping in a shelter, they couldn't simultaneously obey the law. Why? Because there were too few shelter spaces for the number of homeless people in the city. And the court said that this constituted a Section 7 violation of the right to life, liberty, security of the person, because the laws were overbroad and didn't allow homeless people to take down their shelters during the day in such a way that they can comply with the law. He said, so what would make these laws charter compliant is if, there was some point in the day where homeless people could sleep in public spaces if there wasn't enough shelter space, as long as they kind of took them down during the day when most people would want to use these public spaces. And those were the two kind of decisions that arrived at much the same conclusion regarding the constitutional impropriety of these laws. I think that's an important step, although at the same time, I think that there's much bigger problems when we look just beyond kind of a quantitative analysis of how many homeless people are in a particular city and how many shelter spaces are there. One of the reasons is that we don't really think very much about the conditions that exist in homeless shelter spaces. The risk of violence, of theft, of overcrowding, of transmission of communicable diseases. And I think it's hard for the state to guarantee an adequate protection of life, liberty, security of the person through shelters alone. Part of this, I think, militates towards eventually, if not the recognition of some type of enforceable right to housing, as long as the state wants to simultaneously regulate public spaces, at the very least, some type of legislative obligation to continue to improve access to housing as much as possible. So I think when we think about these issues about how to regulate public spaces and whether these encampments have a place, I think they certainly do insofar as the state isn't able to provide some type of meaningful protection to homeless people, both against the enforcement of laws and for their personal security in most matters.
Thank you. Thanks, Professor Skolnik. Next question is for Professor Mathen. Actually, a question I had myself. Can you comment on the mobility implications of regional or intra-provincial travel restrictions? Actually, we haven't seen, I don't think we've seen any of these in the COVID-19 pandemic in Ontario, but there have definitely been other countries where there have been regional travel restrictions. What are your thoughts, Professor Mathen?
Yeah, it's a great question, because certainly in Quebec we've seen that, and but mostly it's been, the policing has been within the provincial, at the provincial border. So you know, it depends on how broadly you want to interpret Section 6, and I think that would particularly be the second clause of Section 6. I think that the more fruitful avenue would be a Section 7 claim for those purely intra-provincial limitations. I think that that would be a more straightforward application of either the liberty interest in Section 7 or the security of the person interest, depending on the effect on the individual. Now, it's true that liberty has traditionally been given an interpretation under Section 7 that it cannot relate to trivial choices. So, but I do think that the COVID-19 context provides the space to really interrogate that. So even though it might seem in the immediate context like a trivial choice to move around, I actually think it's fundamental to a free society. And so in the event that that were to come up, I think the more straightforward route would be to tackle it under Section 7.
Okay, thank you. Maybe one follow-up from me before we get to what seems like a bit of a technical legal question. You know, I'm not a lawyer. I'm guessing there are some non-lawyers in the audience. Maybe most people are lawyers. I see this as sort of a balance between Taylor's right to travel and my right not to be infected with COVID-19, which also seems to me to be a bit of a liberty right, because I want to be free of not being infected. Taylor wants to be free to travel. Why, how, as a non-lawyer, why would the Canadian Civil Liberties Association choose to weigh in on this particular right and not that particular right?
So, so you raise an interesting question. Are there competing rights at play? And really the right to positive action by the state to protect you in this very challenging situation. I think that the traditional model by which we view competing rights is not necessarily at work here, that the right of everyone to be protected by the state is really well represented by the state in its response to these challenges. And I think that the Civil Liberties Association is concerned first about the effect on the individual, which I'll come to in a moment, but also they've been concerned by the way in which these decisions have been made, which they see as somewhat taking advantage of the obviously the extraordinary challenges facing public officials, not allowing for the kind of transparency and even publication of the measures that you would want. I would just say that with respect to your right to be protected versus the individual's right to travel, remember that the measures put in place do allow for people to enter the province. It's a judgment call that's been made in the first instance by the medical official, and even in the context of the extenuating circumstances. And it's interesting here, she did ultimately get the permission. It's just, it was too late to avoid that really painful result for her. That's not to say that that was the wrong decision, but you know, this is exactly where we expect the charter to do its work.
Yes, and I would add any Canadian can go visit one of the provinces in the so-called Atlantic bubble, so long as they agree to quarantine for 2 weeks after they arrive. I think, certainly I know that's true for Nova Scotia. Okay, next question for you, Carissima. Do you see any scope for arguing that Section 6 violates Section 15 of the Charter?
Yes, I saw that from my colleague, John Marquis. So just for people that do not have the knowledge at their fingertips, Section 15 of the Charter protects the right to equality. So I think I assume that what Professor Keyes is talking about is the fact that within Section 6, we have a primacy of rights for citizens versus everyone else. It's citizens that have that primary mobility right. So is there an inequality embedded in Section 6? I think there is. Is it subject to challenge under the Charter? I think it isn't, simply because the courts have taken the view that you cannot use one section of the Constitution to challenge another section, and we had that confirmed in a relatively early Charter case dealing with religious schooling. So the fact that in our initial British North America Act, we provided funding for denominational schools, which would appear to give benefits on the basis of religion, which of course is also protected under the Charter in terms of you're not supposed to give favor to religion, and the court said that's part of the original bargain. And I think what we would say in this context is that Section 6 reflects a political decision that, once it's entrenched, is not subject to challenge on the basis of another aspect of the Charter. I would say that's also why it's important to look to Section 7, because that evades what I think is a problematic result, which is you have mobility rights within Canada for citizens versus permanent residents, when that really doesn't seem to be, it doesn't seem to be justified. It just seems to be in line with the text of Section 6.
Thank you. I feel like I feel like I've been having some thoughts while you've been talking about what it would be like if we invited a lawyer to moderate medical grand rounds at the hospital. It'd be very entertaining. I think this next question is probably for both of you. Can you speak to effective judicial remedies in the context of Charter issues that might already be moot by the time a decision is rendered? Professor Mathen, do you want to answer that one first?
Sure, I can answer that first, and then I'd be very interested in Terry's view. So the most effective judicial remedy that the courts might be inclined to give anyway is declaratory relief, where they will make a declaration as to the constitutional deficiency of either a decision or a regime, because that kind of, even though it's just a declaration, it's not backed up by an order, that is very powerful. That we do take that as a very powerful indictment of other state actors. If it's a law that's in place, then even if the particular individual affect on the person is over, of course the law is still, the court can still in fact strike down that law. But if it's just a decision that was made perhaps by a bylaw officer or a police officer where there's no individual remedy, I think that declaratory relief is really is really important. And I would just point out too that in the context of COVID, I do think that declaratory relief is much more likely. Courts hesitate from issuing injunctions or ordering state agents to do anything, even in the best of times. They are probably less likely to do that in the COVID context, unless the decision is really quite objectionable. Then you might have the courts enter the fray and really bring the hammer down. I think declaratory relief there's a very well settled basis for it in constitutional law, and it is quite effective.
Thank you. Professor Skolnik, would you like to add anything to Professor Mathen's reply?
Very quickly, first, I thought that was a great answer, and I would never have thought of that. So I thought that was a great answer by Professor Mathen. The other thing I would add is maybe it's two, maybe one distinct thing, and I don't know if this fits necessarily within sufficiently within the realm of a constitutional relief, but I'll let you know where I'm going with this. I think one of the big things that changed with COVID is how the criminal justice system has approached, for instance, the right to reasonable and just bail, and when people should be detained in custody pending their trials and when they have to be released. And I think one of the main shifts that happened with COVID is kind of rethinking our comfort in imposing pretrial detention on people. And I think if you look at kind of the past 3 decades of the rise of pretrial detention, it's kind of started to decrease recently in the past couple of years, but over the past 30 or so years, it's risen dramatically. And COVID has kind of forced courts to say, oh, actually, we are supposed to release individuals before their trials because they're presumed innocent. And that's been one of the major effects on the criminal justice system. So I don't think that that's going to be something that's going to become moot later. But my worry is that once, the pandemic is under control, hopefully ASAP, I think there's going to be a recourse to pretrial detention that's going to go on a huge rise, because there isn't this concern anymore that people are going to contract a life-threatening, very dangerous disease while being incarcerated awaiting their trials. So that would kind of be my answer, and you could link it to Section 11E of the Charter, but I don't think it's as tight of a connection as the one Professor Mathen brought up.
Thank you. I think this next question is for you as well. In regards to public health measures around COVID-19 and their impacts on the homeless population, what are alternative measures that can or could have been taken in order to consider and accommodate this population's already existing vulnerability? For example, exemptions from fines, etc.
So I have a pretty revolutionary idea here. I'm being facetious. No, I think we should give homeless people access to a private space, right? If it's a hotel or if it's a motel or whatever it is, that would be much more preferable to punishing individuals whose lives are extremely challenging, and this is even before we're not even in the winter yet. So I think that would kind of be the basic. The other things that you might want to provide are, for example, masks to homeless people, to take more of a public health approach. And with respect to the third aspect of my answer, which goes to what are alternatives to, say, penalizing or criminalizing them, my view is that we should adopt something or we should adopt 2 principles, or think about employing 2 principles. One is the idea of last resort, which means that we don't impose fines, especially on homeless people, unless there's absolutely no other possible option under the sun, which for me, the way I just explained it, would be a very exacting standard. And the second thing would be, in cases where the state's going to coerce people who are impecunious or are experiencing homelessness, you'd want to have something that resembles what's called a day fine model. So if you look at a bunch of Scandinavian countries, they have a model called day fines, which imposes a monetary amount that's equivalent to a proportion of a person's daily adjusted income, which ends up being extremely, extremely, extremely low for people who aren't receiving a lot of income. This might be $2 or something. And then I think would be in exceptional cases that we'd impose a fine that resembles some type of day fine. I think generally you shouldn't impose them, but as a last resort, it would look something more like a day fine model that we have in place in other countries. And they've also used them in certain US jurisdictions, like in Staten Island, or I think in Milwaukee as well. They've experimented with them.
Thank you. We're coming up on the hour, so I'm going to give this one more question to Professor Mathen, and then I will say some concluding remarks, and then we will send you on your way. This last question: fantastic presentations. There seems to be wide discretion involved in the actual deployment of these laws and restrictive measures on the ground, from border crossings to handing out tickets within municipalities, that has led to inconsistent enforcement. I'm wondering on your thoughts on this discretion.
Yeah, it's a very legitimate issue. when you are talking about this level of social risk management, unless you have a blanket prohibition, you are reliant on individual decision makers applying their discretion. I think that in terms of the charter, that choice to not go for the binary black and white, we're just going to close the border, period, versus we are going to permit case-by-case decisions in accordance with standards. As long as the standards are articulated, I think that discretion is certainly, it can be saved to the extent that it would be found to violate the charter. I think it would be part of a reasonable limits analysis, but certainly there is then a bit of a black box in terms of how are those decisions being made. And of course, then we get to, there's just the impossibility of really challenging those in a fruitful way. So it's a real balancing act. It's a tough choice that's been made. And of course, we do know that when you give individuals that kind of discretion, they're not always going to exercise it in the best way, because they're exhausted, because they're confused, because they're scared, because they're overworked, right? And perhaps because there are some biases at work as well.